Hey, wait, sir, what is this? Is this the law? What's going on over here? Your Honor.
You're out of order.
What's going on over here? I don't care what you think. Do something over here.
I think that we have enough.
What do I look like to you, huh? Do something. Do something.
Order!
Your Honor, we'd like to withdraw our plea of not guilty and enter a plea of guilty.
Guilty?
Order in the court! Order!
Guilty!
Welcome to the Lawyer's Justice, where today we're diving into some of the most jaw-dropping legal blunders ever made by lawyers. What you're about to see isn't just a list of bad cases, it's a journey through courtroom chaos that will make you shake your head, laugh, and maybe even gasp at how far some attorneys have gone. Stay with us to the end, because the last case will reveal how technology itself is creating a whole new era of legal absurdity, and you won't want to miss it. From rookie lawyers who accidentally sabotaged murder trials, to professionals who turned minor disputes into multi-million-dollar fiascos, these cases will show you how one bad decision in the courtroom can ruin careers, waste years, and even change the law. Keep watching, because somewhere in here is a case so ridiculous it became a meme around the world. And as we move through each of these 10 unbelievable stories, we're not just exposing the absurd, we're breaking down the legal context, the impact, and what every lawyer should learn to avoid making the same mistakes. By the end of this video, you'll know which lawyer's folly could have been avoided with a single smart choice. In the case of Joseph Rakowski, the legal context was a US murder trial in which a rookie lawyer openly admitted during his first case that he had no prior trial experience. His role as the defense attorney was marked by poor judgment and inexperience rather than malicious intent, but it led to a mistrial within hours. The case didn't create new laws, but it became a benchmark for incompetence, damaging his career and leading to public ridicule. Its absurdity lay in the reckless admission and the irrelevant arguments he presented, wasting court resources and his client's chance at a fair defense. Public reaction was scathing, with media coverage highlighting his ineptitude. Ethically, his lack of preparation breached the duty of care, harming his client. While it did not leave a law on the books, it is now cited as a cautionary tale in legal circles. Humor surrounds it, but the impact was very real for the defendant. The so-called Chewbacca defense originated in US civil and criminal contexts as a strategy to confuse rather than clarify. Lawyers using it intentionally presented irrelevant or nonsensical arguments to bewilder juries. This approach often wasted time and money, though it rarely influenced legislation directly. The absurdity was intentional, less about incompetence and more about manipulation. Public reaction turned it into a pop culture joke, especially after its depiction in media, and it sparked debates about courtroom tactics. Ethically, it skirts the edges of malpractice when it sacrifices justice for confusion. Today, it's cited as a textbook example of how not to argue a case, maintaining a strange place in legal folklore. In Linwood v. Andrews, an English case from 1888, the lawyer allowed false affidavits to be submitted, leading to loss of property for the opposing party. His role was deliberate, he knowingly enabled fraud. The impact was severe, he was found in contempt and imprisoned. The absurdity was less comedic and more shocking for its blatant disregard of the law. Public reaction at the time treated it seriously, and it highlighted the risks of unchecked legal authority. Ethically, it was a clear breach of duty, bordering on criminal conduct. Though the specific case didn't create an enduring law, it remains an example in legal ethics discussions, reinforcing the importance of honesty in affidavits. The Pepsi Jet lawsuit took place in the United States and revolved around a civil contract claim, where a lawyer pursued a case arguing that a commercial promising a Harrier jet in exchange for points should be honored literally. The lawyer's role was aggressive but arguably misguided rather than malicious. The case had no legislative impact but became a landmark example of frivolous litigation after being dismissed. Its absurdity lay in treating a satirical advertisement as a binding contract, wasting significant legal resources. Public reaction was widespread ridicule, and the story entered pop culture lore. Ethically, the case did not breach care in a serious sense but was seen as exploiting legal loopholes. It remains cited in advertising and contract law education as a what not to pursue moment. Tony campaign's Supreme Court argument in the US, where he used crude humor about diarrhea to argue against certain ad campaigns, was a case of poor courtroom decorum in a constitutional law context. His role was one of self-sabotage through inappropriate remarks, which neither helped the case nor impressed the justices. It didn't influence laws but tarnished his reputation, leading to malpractice concerns. The absurdity factor was high due to the inappropriateness of his language in the nation's highest court. Public reaction was largely one of disbelief and ridicule. Ethically, while not outright fraudulent, his behavior reflected a lack of professionalism. Its legacy is one of infamy rather than legal precedent. The cat hazard case involved an insurance lawyer in a civil claim, where he argued that a cat was a foreseeable occupational hazard for a painter who slipped and was paralyzed. This occurred in the US and dragged on unnecessarily. The lawyer's role was persistent but misplaced zeal in stretching liability theory to absurd lengths. The impact was largely a waste of time and resources with no lasting law created. Its absurdity made it stand out as a comical courtroom stretch. Public reaction was muted outside legal circles but often used as an example of over-lawyering. Ethically, it was not fraudulent but bordered on exploitation of the system. It left no formal legacy except as a cautionary example. The case of the generic Martian in Canada involved a man claiming to be a Martian suing a dental college. Lawyers involved had to respond to this claim, but the absurdity mainly came from the plaintiff's identity claim. The legal context was civil, and the lawyer's role was to navigate an obviously frivolous lawsuit. The outcome was dismissal, and no law changed. The absurdity lay in the premise of a non-human seeking standing in court. Public reaction was bemusement, with media treating it as a quirky story. Ethically, the lawyers acted properly, but the case highlighted the necessity of gatekeeping frivolous claims. It left no serious legal precedent but is often cited in strange case compilations. Judge Roy Pearson's $67 million pants lawsuit in the US was a consumer civil case where a lawyer, acting as his own attorney, escalated a lost pants complaint into a multi-million-dollar demand. His role was both instigator and executor of the absurd claim. The case had no positive legal impact, resulted in his dismissal as a judge, and damaged his public image. The absurdity was extreme due to the disproportionate damages sought. Public reaction was global ridicule, turning him into a meme of legal excess. Ethically, it was considered abusive of the system. Its legacy is enduring as one of the most famous frivolous lawsuits. The Andrew Ornenheimer, Weave, CFA challenge in the US involved a defense attorney using novel and confusing arguments to overturn a computer fraud conviction. The lawyer acted deliberately, with some success in getting the conviction overturned, though the methods were controversial. The impact did raise debates about the Computer Fraud and Abuse Act. The absurdity was in the legal reasoning's complexity and the public perception of defending a notorious troll. Public reaction was mixed, admiration from some, ridicule from others. Ethically, it was within bounds, though provocative. Its legacy is more substantive than silly, but it's remembered as a wild legal ride. Michael Cohen's AI-generated fake citations case occurred recently in the US, where a lawyer submitted court filings containing fabricated cases generated by artificial intelligence. His role was negligent, not malicious, relying on unverified AI output. The impact was embarrassment and judicial rebuke, though no law was created. The absurdity lies in citing imaginary law in real court. Public reaction was sharp, with heavy media coverage. Ethically, it breached competence standards but not intentional fraud. Its legacy is a modern cautionary tale about technology misuse in law. And there you have it, 10 cases where lawyers turned the courtroom into a stage for the absurd, the careless, or the outright bizarre. Some wasted years of legal effort, others damaged reputations forever, and a few even reshaped how courts handle frivolous claims. If you've stayed with us this far, you've seen how even a single reckless argument can spiral into a legacy of ridicule. Before you go, remember, these aren't just funny stories, they're warnings. Law is powerful, and those who wield it without care can change lives, for better or for worse. Subscribe to The Lawyer's Justice to uncover more shocking, unbelievable, and sometimes hilarious stories from the courtroom. Next time, we'll show you a case where a lawyer's plan to win big turned into a career-ending disaster you won't believe.